because you put it like that and you have to worry about them falling over.
Do behind you.
No, no.
I have a question for you eventually, and I have some ideas about things we might be doing in our classrooms. And I need to
The
talk to
thing
you
you do
about
is you have something
like a Bible holder.
yeah.
I bet you. I'll see what I can do. Good afternoon. I'm Dean Jessica Berg, and I am welcoming you here today to our lecture. I was going to say, usually this room is freezing, and so I find the title really ironic, but it actually does feel a little warmer in here. Professor Jonathan Adler, who is the director of our new Environmental Law Center, and a renowned expert in environmental law, constitutional law, and a variety of other areas of regulation, is going to speak to us today on It's Getting Hot in Here, about climate change cases heating up in the federal courts. I'm going to turn it over to him since you really don't want to listen to me. He's going to be much more interesting. Please feel free to continue to eat and get anything else you need, but please welcome Professor Jonathan Adler.
Thank you. Thanks for folks for coming, especially those who are on the Law Alumni Association board as well as others. It's a ton to cover. I know I'm supposed to begin with a joke. That's how you're supposed to begin a talk. My kids regularly tell me I'm not very funny, so I'm going to dispense with a joke because trying to talk about climate change itself, trying to talk about climate change policy, trying to talk about climate change in federal courts, it's a massive topic. We could do a year-long course on this and still not cover it. And so I'm going to try and do it a tiny bit of justice in an hour, or actually a little less than an hour, so I can take some questions. So I'm going to get right into it. Very timely subject. Some of you may have received the most recent copy of the ABA Journal. It's this topic, the fact that climate change is coming in federal courts. Climate change cases are here. Climate change questions are pervasive policy questions and pervasive legal questions. Just this week, President Trump formalized the announcement that the United States will be formally withdrawing from the Paris Agreement on climate change, I guess a year from now, given the procedures of that treaty, that the process has to begin with the formal announcement. Just this week as well, a trial in New York, not in federal court, but a lot of what I'm going to talk about today involves bouncing between. Is this echoing a lot? Can we turn it down, or is it good? Should I have it? All right. A case concluded in New York. The New York Attorney General is claiming that Exxon misled shareholders or at the very least issued false statements with regard to the financial implications of climate change, and that this violates the Martin Act. That case ended, as I said, this week, and it looks like it's ending more with a whimper than a bang based on the press reports, but we shall see. We don't have a verdict yet, but that concluded this week. 2 weeks ago, the Supreme Court was presented with orders or petitions seeking orders to alter pending climate cases. It rejected those, and as I'm going to talk about, there are tons of cases in federal court. There is just a tremendous amount happening, and happening very, very quickly. In terms of climate change, what we're talking about, I'm going to give you one slide showing you what the greenhouse effect is. I'm going to give you a very oversimplified explanation for those of you that are not aware. Basically, we have a natural greenhouse effect. It makes this planet livable. We're happy with that. That the atmosphere traps in a certain amount of solar radiation, which maintains temperature at a livable level. The concern with climate change is that as the accumulation of certain gases certain gases accumulate in the atmosphere, in particular carbon dioxide, but not exclusively carbon dioxide, methane's another one, there are several others. The accumulation of those gases in the atmosphere increases the heat trapping potential of the atmosphere. So less of the heat escapes, more of that heat is retained in the atmosphere. That in turn not only increases mean temperatures, it also has other effects on climate systems. It affects cloud formation, it affects precipitation rates, it affects all sorts of other things. As I said, we could spend a week just talking about this. There's generally, in the courts, has not been much dispute about this. I'm going to talk about a whole bunch of cases. And one of the things that's interesting, in almost none of these cases is the basic scientific understanding disputed. So we have a whole bunch of cases in which cities, states, other entities are suing oil companies, are suing the federal government. And in those cases, the defendants in those cases are not putting the basic scientific understanding at issue. I think there are sound reasons for that, but given the debate we may hear elsewhere about the science of climate change, it is certainly interesting that when Exxon or Chevron or whomever has billions of dollars on the line, they don't think that they can defend themselves by challenging the basic scientific understanding, and that should tell us something about what the basic scientific understanding is. There is debate about what happens to snowfall, or what happens to rainfall patterns, or what happens to cloud formations, and the extent to which certain feedback systems moderate or accelerate certain aspects of the greenhouse effect, but the basic underlying dynamics are not in dispute. A few more things just on the basic science. Here's global mean temperatures. This is from NASA. We see a dramatic increase in global mean temperatures, and it's something that should be concerning. It's not just global these are land-based temperatures. Land-based temperatures are, in the one sense, a good, solid, long record. It's, in that we have actual temperature records. On the other hand, there are reasons that we sometimes worry about the reliability of the land-based record. Basically, a lot of these thermometers were originally placed in the middle of a field, and 50 years later, they're in the middle of a city. And we know that doing things like putting down asphalt will affect temperature readings. So we sometimes worry about whether or not we are accurately accounting for other things that could affect this data. Fortunately, we're not just reliant upon land-based records. This is satellite records. And what's interesting about these records is these records are based on satellite devices done by the University of Alabama at Huntsville and NASA that were set up and maintained by a pair of scientists who were personally quite skeptical of many climate change projections. And yet even the data that they curate is showing an increase. This is data that only goes back to the late 70s, but it is showing warming in the atmosphere where we would expect it based on the accumulation of greenhouse gases. In terms of greenhouse gas emissions, these are charts I pulled off of EPA's website this morning. And the one on the left is long-term trends in carbon dioxide, and you see that giant jump at the end, and then the one on the right is just 1950 to 2015, dramatic increases in greenhouse gases measured in terms of carbon dioxide equivalent. And most of that is due to us. Some more, this is global CO2 emissions. This gives you an idea of what we've seen over the last several decades, and you can also see where it's coming from. You can see the United States emissions, certainly for the last couple decades, have been stable or maybe even declining a little bit. You see massive increases in China. You see significant increases in non-OECD countries. The United States is now responsible for about 13% of annual emissions. So a significant chunk, but not nearly as big a share as it was, say, 20, 30 years ago. In terms of where it comes from, in the United States, transportation, nearly a third, electricity, right behind it, 28%, industrial use, 22%. It's energy use. The vast bulk of our greenhouse gas emissions come from energy use. Energy is obviously incredibly important. Carbon-based fuels as an energy source have been they've been an incredibly effective and efficient energy source, and getting away from them is certainly one of the things that makes, or the need to get away from them, one of the things that makes climate change such a challenging issue. Also, the fact that these emissions come from so many places, as I'm going to talk about, makes this a more challenging issue for the courts. It's not like old-fashioned pollution cases where there's one facility or there's a handful of facilities and you can sue that one facility or that one company or even that one industry, because you're not actually capturing a substantial share of the relevant emissions that way, and we're talking about a phenomenon that occurs in the global atmosphere. So that makes it challenging for policymakers, that makes it challenging for courts, and I'll talk about some of the legal doctrines that we have a hard time figuring out precisely how they apply, given this sort of background. This is also just U.S. primary energy consumption by major sources. You can see that dark blue at the bottom, coal has dropped off. That's a good thing. Natural gas has expanded and is largely responsible for that, but we still see we have a substantial amount of petroleum use in terms of energy, sources of energy in the United States. Transportation are obviously a huge part of that. Nuclear is there, not increasing in the United States, globally not increasing, and a lot of people think it's going to shrink. And renewables are there, have grown quite a bit, but are still a relatively small player compared to other sources. So that's just to give a sense of the landscape about which we're going to talk about this. So let's talk about court. And at some point, or at the end, like I said, I'm going to give time for questions, but let's talk about litigation. As I mentioned to you before, this is a massive topic, tons of suits. There's a report that was just released this summer, and this is climate cases in U.S. courts. First case implicating climate change filed in the 1990s. You see just a massive explosion. These are the colors are based on who the plaintiffs are. And they're including all sorts of climate change cases. I'm going to focus on a few select types, but climate change as an issue that courts are having to confront has, in the last 10 years, as this chart shows, just completely blown up. It is everywhere. You could do similar charts looking around the world. By some estimates, these are tracked by the Sabin Center at Columbia University's Law School. By their estimates, there have been somewhere in the neighborhood of 1,300 climate change cases filed around the world since 1990. Of those, over 1,000 were in the United States. So we see this dramatic increase globally, but the bulk of it is occurring here. In terms of climate change in court, I'm primarily going to talk about two types of cases and two sets of cases. I am oversimplifying. I am leaving things out. So if you come away from this talk going, wow, there's a lot going on, there's a whole iceberg underneath the surface. You've seen that little bit sticking out of the water. There is a lot more. First set of cases that I think that I'm going to talk about, and the ones that we saw first, and the ones that arguably have the ability to crowd out a lot of the others, are what we might just characterize as administrative law cases. Agency rulemakings. The EPA in the Obama administration trying to regulate, in the Bush or Trump administration trying to not regulate or trying to regulate less. Permitting decisions, challenges to various decisions about permitting of facilities, pipelines, and so on. NEPA decisions. Under the National Environmental Policy Act, federal agencies, before they engage in a significant action, are supposed to conduct environmental impact statements. They are supposed to consider climate change impacts. They have not always done such a good job of that. There are a lot of Freedom of Information Act cases. Cases about what does the government know, when did it know it, what sort of data does the government have, that sort of thing. And then there are a bunch of cases that we might characterize as preemption cases. Some of those brought by the federal government, some of those brought by private entities, and then a subset of those which I'm calling administrative law cases just to keep things easy. There are dormant commerce clause cases. There are a whole range of cases bouncing around in the federal courts, challenging various state laws that are trying to reduce greenhouse gas emissions, increase renewable fuel use, reduce the carbon content of energy sources that are being challenged as potential violations of the dormant commerce clause because of their effects on interstate commerce and interstate energy markets. Those are the high points. There are others. There are Endangered Species Act suits. There are all sorts of other suits as well. But that's one bucket of cases that I want to say a little bit about. A second bucket of cases we might just loosely characterize as common law cases. Nuisance suits. We have a whole bunch of those, and they're bouncing around between federal and state courts. And some of we have a few suits that are based on negligence theories. We have a bunch of suits, mostly in state courts, although there's one very big one, which I will get to, in federal court that involves claims that there is a common law public trust doctrine that states and perhaps even the federal government must observe, and that they are not. Again, there are all sorts of other cases, and there are other contexts in which we are seeing climate change. So, for example, the Supreme Court right now is considering a cert petition in a defamation case that was brought by a prominent climate scientist named Michael Mann, who had some not nice things said about him and sued for defamation. And the defendants in that case believe that the lower court, or the courts in the District of Columbia that heard that case, did not apply the proper standards. So climate change is popping up all over the place. But for purposes of this talk, I want us to think primarily about these kind of two buckets: cases that involve how climate change interfaces with our system of regulations and system of government actions, those administrative law cases, and then how climate change can or cannot be the basis of suits using traditional common law sorts of causes of action like we see in nuisance cases. I think if we think about those two buckets, that's a way to get a sense of the broader landscape that we are dealing with. So let's talk about some of these administrative law cases. Let's start with Massachusetts versus EPA, the first time the Supreme Court had to deal with climate change. This is a case the Supreme Court decided in 2007. I don't know how well you guys can see this, but this is a map of part of Massachusetts' coastline with projections of sea level rise that it was anticipating as a consequence of the human contributions to global climate change. Massachusetts' claim was that the Environmental Protection Agency had violated the Clean Air Act by denying a petition asking the Environmental Protection Agency to regulate greenhouse gases under the Clean Air Act as pollutants. A handful of activist groups in the 1990s had filed this petition with the EPA. The EPA sat on those petitions. The Clinton administration said, we think they might be right about our authority, but we're not so sure we want to do this. It was seen as a real big political hot potato. When the Republicans took Congress in the 1990s, they actually denied EPA the use of funds to act on the petition. So when Congress enacts appropriations bills, it's allowed to say, yes, you're allowed to do this under the law, but you just can't spend money on it. Congress does this a lot, and it does it a lot in environmental law. And so nothing happened with the petition. The Bush administration comes in, Congress thinks, the Republican Congress thinks, well, now that we have a Republican president, we don't have to tie their hands anymore, so they remove the appropriations rider. The Bush administration, when it realizes it's about to get sued for not acting on this petition, denies the petition. It rejects the Clinton administration interpretation of the Clean Air Act. It says, you know, we've looked at it. We don't think greenhouse gases are what Congress meant by pollutant under the Clean Air Act. Congress meant things like particulate matter and ozone and nitrogen oxides and the like, lead even, carbon monoxide, but not carbon dioxide. And so we don't have the authority to regulate greenhouse gases. And even if we did, EPA said, because we believe climate change is a really important problem, and this is a strategic matter, this may not have been the smartest thing for them to do. Climate change is a really big problem, but there are all sorts of other things that we would rather do, even though Congress might not have authorized them. And that's how they denied the petition. And Massachusetts sues, and it goes all the way up to the Supreme Court. And the Supreme Court deals with three questions, all of which are important, kind of understanding what's happened with climate change law since. The first question is standing. The question, which is a question of whether or not the court has the jurisdiction to hear the case. For those of you that need the quick refresher, Supreme Court has told us that Article 3 case or controversy requirement of the Constitution means that for a court to hear a case, there must be an actual case or controversy. There must be an aggrieved party that has suffered an injury in fact that is concrete and particularized and actual or imminent, that implicates a legal right that a court can redress. That you don't just get to say, oh, someone's doing something wrong. You have to be someone that is injured or affected in a way that implicates a judicially cognizable right. And the reason this is an issue in climate change is because we're talking about the global climate. And a good rule of thumb in standing cases, I'm oversimplifying a little bit. I know I have a couple students here, and so they shouldn't put this on their exams. But a good oversimplification is that if everyone has standing, no one has standing. That's not always true. There are certain areas where that's not true, but as a general matter, to claim Article 3 standing, you typically have to be able to say, I've suffered an injury, in fact, that is concrete and particularized to me. Something in particular has happened to me. And so, for example, if you think the federal government is spending money unconstitutionally or unlawfully, you don't get to go into court and say, well, as a taxpayer, I object. The courts will say no standing. You might be right. The government might be flagrantly violating the law. Too bad. And the reason is that's an undifferentiated interest that all taxpayers share. There's no basis for standing. Now, I should note some states allow that type of standing. Ohio sometimes allows taxpayer standing, but in federal court, we don't allow that sort of generalized grievance to be a basis for standing. And in standing, we care about two things. We care about the kind of the concrete and particularized nature of that injury, and we care about the injury being actual or imminent. It's happening now or it's about to happen, not someday in the future. And the challenge with climate change and the challenge that Massachusetts faced is Massachusetts wanted to say, we are going to lose coastline. The seas are going to rise. Well, when? Well, over the next 100 years. And that was a problem for Massachusetts, because on the one hand, they want to say concrete and particularized, an actual thing that injures Massachusetts in a way different than, say, Ohio, our loss of our coastline. That's a distinct particularized injury to Massachusetts. But Massachusetts couldn't say, in 2008, here's how much coastline we're going to lose. And so there was a tension about how Massachusetts could satisfy both. And so that was a big issue. There's a second issue about authority to regulate under the Clean Air Act, and then whether or not the EPA properly denied the petition. Let me say a tiny bit more about standing. The court, 5-4, decided that Massachusetts had standing. And it did a couple things that kind of eased Massachusetts's burden to make it a little bit easier to have standing for climate change purposes. One, it said states aren't normal litigants for purposes of standing. This was the announcement of something that we now refer to as special solicitude for states. What does that mean? We're not sure. The Supreme Court has yet to, in the last 12 years, has not elaborated on this, but it has said at least for purpose, at least states, if not the rest of us, have a little bit extra ability to invoke the jurisdiction of the federal courts. And if you wonder what gave attorneys general the idea, both during the Obama administration and the Trump administration, to sue presidents of the opposite political party over just about everything, this part of the Massachusetts case helped grease the skids for that. Other things the court said, it said that the Commonwealth of Massachusetts is entitled to a special solicitude. I said that. And it also said that a litigant to whom Congress has accorded a procedural right to protect his concrete interests, here the right to challenge agency action unlawfully withheld, can assert that right without meeting the normal standards for redressability and immediacy. Put in other terms, where Congress has said you are allowed to sue, we're going to be less worried about what sort of tangible relief you get. Can Massachusetts show that if it wins the case against the EPA will regulate in a way that's sufficient enough to reduce greenhouse gas emissions enough, to reduce global warming enough to save Massachusetts coastline? We're going to lessen the need to show that. And we are going to lessen the normal standard for immediacy. We're going to say that the fact that this may be something that is occurring slowly or is going to manifest itself over a longer period of time, we will be less concerned about. And it so happens in the Clean Air Act, like in most federal environmental statutes, there is a provision that says people get to sue when the agency breaks the law. And so the court found that these two things were sufficient to allow Massachusetts to sue here. And this was, the first time the Supreme Court had allowed for standing in raising this sort of claim. And so it's of a lot of importance. Other thing it said was that the risk of catastrophic harm, though remote, is nevertheless real. That risk would be reduced to some extent if petitioners receive the relief they seek. Massachusetts doesn't have to show that climate change ends if they win. They don't have to show that it reduces things in a measurable way. They just have to be able to assert, which we can accept, that if EPA regulates, there will be fewer greenhouse gas emissions, and if there are fewer greenhouse gas emissions, there will be less climate change. How much? Well, according to the affidavits Massachusetts submitted in the case, it would have actually meant a difference of less than an inch of sea level rise by the year 2100. So in this context, the court said there's a right to sue, there's a state suing, even though this might seem like a really, really small effect, it's okay. Massachusetts can sue. And that's a hugely important part of the case. Since this case, the Supreme Court has been asked to revisit questions of standing related to climate change. The last time it was asked to do that, it split 4-4 because one Justice Sotomayor, was recused. At least as applied to climate change, there's no reason to think that this holding is going anywhere, although at the end I'll suggest one thing to watch. In terms of the other aspects of the decision that were really important, the Supreme Court said that under at least this provision of the Clean Air Act, Section 202, greenhouse gases are an air pollutant. And the EPA was wrong to say otherwise. And the reason it matters for this provision is because what this provision says, I'm oversimplifying, you can see the text behind me, is that if the administrator, in his judgment, believes that the emissions of a given pollutant will cause or contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare, the administrator shall regulate, shall by regulation prescribe standards. This particular provision is about motor vehicle emissions. It's important to note this language is very precautionary, right? It doesn't say the administrator has to prove this is going to happen. It doesn't say the administrator has to meet some particular evidentiary threshold. It basically says if in the administrator's judgment, these emissions cause or merely contribute to things that could be reasonably anticipated, right? It's a very low threshold. And the Bush administration, as I noted before, in denying the petition that led to this case, said, oh yeah, these emissions are contributing to problems that are going to cause, contributing to climate change. It's going to cause problems. We just don't think the Clean Air Act is a good tool. Well, based on what the Bush administration put in the record, the Supreme Court said greenhouse gases are pollutants, the die was cast, greenhouse gases would be regulated under the Clean Air Act, and they are. The Supreme Court didn't say, EPA, you must regulate. It said, EPA, you must base your decision based on the standards in the statute, i.e. the standard here. Does the emission of greenhouse gases from motor vehicles cause or contribute to air pollution reasonably anticipated to endanger the public health or welfare? And as I said, the Bush administration had said yes, the Clinton administration had said yes. There are literally thousands of pages of documents from the EPA that the EPA would have to disavow to not be obligated to regulate as a consequence of Massachusetts versus EPA. That is one reason why, despite lots of talk about the Trump administration trying to completely unwind all greenhouse gas regulation under the Clean Air Act, it's not something they've tried yet to do, because they would essentially have to disavow thousands of pages of statements over decades by the EPA saying that this standard is met. And that's just not something that any administration could likely do in a way that would satisfy a court. Consequences. Easier to demonstrate standing in climate change cases, big consequence. And that matters a lot for cases like NEPA cases. The special solicitude for states, we think, is a consequence. Again, the Supreme Court hasn't quite told us what that means. Lower courts have tried to avoid putting too much weight on it, but states certainly feel like they can sue more as a result of this. Greenhouse gases are air pollutants under the Clean Air Act, and that, for all practical purposes, meant EPA had to recognize that greenhouse gases do cause or contribute to air pollution that may be reasonably anticipated to endanger public health or welfare. EPA then began regulating. First was motor vehicle greenhouse gas emissions. That was the thing initially triggered by this decision, but then the Obama administration began to develop stationary source regulations under various provisions of the Clean Air Act. But one thing that's also interesting here is that the EPA also began to encounter some problems. Because whether or not the Supreme Court was correct in Massachusetts versus EPA in the way it interpreted the Clean Air Act, we do know that certain provisions of the Clean Air Act were based on certain assumptions about where pollution comes from, how much comes from how many places. In general, it assumed that, especially when we're talking about stationary sources, there are hundreds, maybe thousands of the relevant facilities, not hundreds of thousands or millions. And that they emit emissions in at certain levels that makes them relevant for regulation. Turns out that greenhouse gases are emitted by far more things at far higher levels. And when you apply the thresholds that are written into the Clean Air Act to greenhouse gases, you have a problem. What kind of problem? Well, the way the Obama administration described it was that the number of permits under the PSD program that the EPA would have to now process would increase more than 140-fold, from 280 permits per year to over 40,000 permits per year. This is the Obama administration's estimates about what would happen when they apply the stationary source provisions of the Clean Air Act to greenhouse gases. Increase the number of Title V permits from 15,000 a year to about 6 million. And the costs to the agency alone for the PSD permits, this is to EPA, and note that a lot of the work on permits is done at the state level, but the cost to EPA itself would be $250 million a year for the PSD part, and that to do the Title V permits, it would require an estimated 340 million person hours at a cost of over 15 billion per year. Money that we know that Congress is in no rush to appropriate to EPA. EPA's budget has not really been increasing its staffing. For those of you that were here for Administrator Wheeler's talk a month ago, he noted that staffing at the EPA has declined significantly over the last few decades. So what the proposed response to this by the EPA was to say, well, we can't apply the numerical thresholds in the Clean Air Act to greenhouse gases. So we are going to instead only apply the regulatory provisions to the biggest of the biggest greenhouse gas emitters, and if we are able to, over time, slowly lower that threshold. And that case went, the EPA also said the massive influx of permit applications would, quote, overwhelm permitting authorities and administrative resources. So their answer was to say, we'll just kind of do it little by little. Problem is that that's not what the statute says, and that case went up to the Supreme Court, and the Supreme Court held 5-4 that insofar as climate change presents a problem for existing statutes and existing regulatory regimes, the response to that cannot be the agency disregarding what Congress put in the statute. The agency might be able to decide that certain parts of the act actually don't apply to greenhouse gases, which is part of what the Supreme Court instructed EPA to do in this case. And Congress can certainly revise the statute, hint, hint. They didn't take the hint. But the agency doesn't get to itself rewrite the statute. That's Congress's job, not the agency's job. And our job as the court is to enforce what's in the statute. Now, that was a 5-4 decision. There were 4 justices that said, look, Congress made a distinction between major sources and others and smaller sources. Let's just allow EPA to tell us what that distinction is for purposes of greenhouse gases, because they're just a different type of problem and a problem Congress wanted addressed. But the court was not willing to do that. And that means in a lot of areas of administrative law where climate change presents really big problems, insofar as we think those are problems related to administration or the operation of programs, the ball is in Congress's court. And for the time being, at least, that means that not much happens. There is a new EPA. That's Andy Wheeler standing where I'm standing from a few weeks ago. The Trump administration is trying not to present those sorts of problems to the courts. It is instead trying to roll back or relax various regulations. And the Trump administration has begun the process of trying to undo some of the climate change regulations that the Obama administration adopted. It is not challenging the Obama administration's conclusion that greenhouse gases contribute to climate change. It is not, as a formal legal matter, challenging the conclusion that climate change poses a threat that must be addressed. It is merely saying the Clean Air Act either prevents certain types of regulation, doesn't require certain types of regulation, and insofar as the EPA has discretion to do less, it will do less. And as I think you all know, anytime you get significant changes in environmental regulatory policy, that too ends up in court, because when EPA issues final regulations, we get lawsuits. And we hear a bunch. The Affordable Clean Energy Rule, which the Trump administration finalized, which is the replacement of the Clean Power Plan under the Clean Air Act, that is being challenged in court. Its decision to revoke the waiver that California gets that allows California to set its own vehicle emission standards, that is being challenged in court. It is trying to, or it is about to, and there's been news on this within the past week, we are supposedly about to get a final rule that will, to some degree, relax federal vehicle emission standards for greenhouse gases, and that is going to be, the administration is claiming, will preempt California's ability to set its own standards. That we know will be challenged in court. The administration has revised rules relating to methane emissions from things like oil and gas development. The Obama administration had promulgated rules trying to control those emissions. Methane, while it's emitted in far smaller quantities than carbon dioxide, is a more potent greenhouse gas. Methane emissions are quite significant. There have been suits announced challenging those revisions. And then there are some cases that are being brought by the federal government. So those first four are just the four highest profile examples of the federal government getting sued by states or by environmental groups or by others for its actions on climate change. The administration is also filing suits. So for example, a few weeks ago, the Department of Justice announced that it was filing suit against California, alleging that California's cap and trade program for greenhouse gas emissions is unconstitutional and unlawful insofar as it allows for trading with Quebec, because it is a agreement with a foreign entity that was not approved by Congress, and so according to the Department of Justice, infringes upon the federal government's foreign affairs powers and violates the compact and treaty clauses of the Constitution. So we get some cases like that as well. And then I don't have time to talk about, but there are a lot of NEPA cases about how agencies evaluate climate change impacts when they're doing environmental impact statements. There are Endangered Species Act cases. How do we think about the fact that climate change is affecting habitat, which affects our assumptions about what sorts of things threaten endangered species over what timescales, and how do we expect the Fish and Wildlife Service to process that, and then a whole bunch of others. These are the peaks, peeking through the clouds. There's a lot more underneath, but I need to talk about the common law cases, which I think is, oh yeah, and the Dormant Commerce Clause cases. But let me talk about the common law cases. So we know, going back at least to the 17th century, a case called, the first reported case that we know of is William Aldred's case. It's the first reported instance of this Latin phrase, which I will not mangle by trying to pronounce for you, but those of you that took Latin can sound it out in your head. It translates to loosely the idea that you are allowed to use your property so long as you don't infringe upon the ability of others to use their property as well. It's Ben Franklin's "my right to swing my fist stops at your face" sort of notion. It's the idea that we all, whatever property rights we have, it doesn't allow us to use property in a way that inhibits the quiet enjoyment of our neighbors. William Aldred's case involved William Aldred, and it was an air pollution case in the 1600s. Somebody had a pig farm next door. And, we didn't have scientific studies about, the pig manure gets in your water, it's going to lead to this bacteria. He knew that it smelled, and he didn't like it, and he sues. And this is a great fun case to go back and read, because you read the case and you could be reading something out of a modern case, because apparently the pig farm owner comes back and says, well, look, I am providing food for the town. I am providing tremendous economic value for our town. People are fed because of me, and his sensitive nose should not get in the way of my ability to provide this immense benefit to the community. And the court says that's not how it works. He has a property right in his home. You are infringing upon that property. You are engaging in activity which is itself independently perfectly legal. There's no 17th century law against pig farming. But you have to do your pig farming in a way that does not prevent other people from being able to make similar quiet or take similar quiet enjoyment of their own property. And that's a principle that goes back in our legal system, like I said, back to the 17th century. And a lot of early environmental cases are essentially nuisance cases. Right? We have cases in the late 19th and early 20th century when the progressive smoke control movement was in full gear, where you had lots of nuisance cases against factories and the like. It's one of the reasons why in a lot of cities you saw facilities pushed to the outskirts of town because they were recognized to be nuisances when they were operating near populations and producing effects that we understood, right? I mean, obviously our understanding of the way pollution travels today is far more sophisticated. One problem with common law actions is it's kind of easy when you've got, one guy and you got the pig farmer next door and he's the only pig farmer. And when you can smell the pigs, you know where that smell's coming from. Or where there's one factory, or there's one entity that's dumping stuff into the river or the stream and so on. One thing we've realized is that, especially in a modern industrialized world, it's often not so simple, right? It's not one house and one pig farm. It's lots of factories upstream and it's lots of homeowners downstream. And we have issues not merely of the fact that these effects can be cumulative and that there may be ecological thresholds that get exceeded when a certain amount of loading occurs, but also just even figuring out where the stuff come from, who's responsible. And if it's affecting lots of us, does that mean we all have to sue individually, or can we sue individually? Is there collective action problems? And certainly one rationale for environmental regulation is the fact that this is messy. And that if we just say, well, all factories have to meet this standard, that solves that problem. This is like complicated normal pollution problems, right? Climate change is more like this, right? Because we're all emitting, driving cars, operating, heating and cooling our homes, doing all sorts of other things. And it's not as if the emissions are in one place and the people receiving the effects of those emissions are somewhere else, because those emissions go to the global atmosphere, which in turn affects us all. So one challenge that courts have been trying to figure out is, how do we apply this underlying principle? Your right to use your property does not allow you to use it in a way that pollutes your neighbor's property, that floods your neighbor's property, that causes other foreseeable, predictable effects on your neighbor's property, on their home, on their person. That is a bedrock principle in our legal system. But to operationalize it, it typically requires being able to figure out who's causing that effect, how much of that effect are they responsible for, can we meet the evidentiary thresholds for documenting that, and is the suit such that it's actually worth bringing suit? One reason why, for example, the fact that Massachusetts could sue in Massachusetts versus EPA is important is because Massachusetts, as a political entity, might be willing to sue over things that any one of us individually might not be as inclined to sue over, or have a harder time suing over, because our fractional interest in that cause is so small. Class actions obviously are one mechanism that we use to deal with similar sorts of problems in a lot of contexts. But climate change presents this problem, right, a millionfold. And it's frustrated some of these efforts. Now we have started to get nuisance suits. The first one, and the one that the Supreme Court has dealt with directly, is this case AEP versus Connecticut. AEP is American Electric Power. Connecticut and a bunch of states sued the 5 largest greenhouse gas emitters as corporate entities in the country. And American Electric Power, they begin with A, so they get listed first. And they said that these 5 corporations were causing, or at least contributing to, the public nuisance of climate change, and that this was a public nuisance under federal common law. And this suit was actually brought at the same time that Massachusetts versus EPA was brought. The idea was that the states assumed that they would win one of the cases because the legal theory to defend against one would undercut the legal theory defending against the other and vice versa. And they were right. They won Massachusetts versus EPA. When this case gets to the Supreme Court, one of AEP's defenses is Congress has enacted the Clean Air Act. The Clean Air Act, as a federal environmental law, displaces federal common law actions for things that are potentially regulatable under that statute. Therefore, federal courts cannot hear these cases under federal common law. And it's displacement, not preemption, because whereas preemption might be disfavored, displacement is actually favored. And there are cases from the 1970s involving the Clean Water Act that found the adoption of the Clean Water Act meant that downstream jurisdictions could not sue upstream jurisdictions under federal common law for nuisance. And the Supreme Court unanimously said, yep, that's right. It was asked initially to resolve these questions. Is global warming a public nuisance? Did greenhouse gases emissions contribute to that nuisance? The Supreme Court only cared about that last question. Is the claim justiciable? It split 4-4 on the question of standing, but on the question of whether or not there was a cause of action that could be maintained in federal court, Supreme Court said no. Unanimously, in opinion by Justice Ginsburg, court said it is an academic question whether in the absence of the Clean Air Act and the EPA actions the Act authorizes, the plaintiffs could state a federal common law claim for curtailment of greenhouse gas emissions because of their contribution to global warming. Any such claim would be displaced by the federal legislation authorizing EPA to regulate carbon dioxide emissions. We don't know if climate change is a nuisance. What we know is that if it is, any such claim is displaced by the existence of the Clean Air Act. And if you go through the opinion, it makes clear that it's not dependent upon the EPA actually using its statutory authority. It is dependent upon the fact that Congress has enacted the statute. So the Trump administration's attempts to roll back Obama regulations probably don't make these sorts of cases any easier to file, at least in federal court under federal common law. And that's an important distinction. Other thing I'll just note, and this is a paragraph that a lot of folks who are against these suits will highlight, is that the court said it is altogether fitting that Congress designated an expert agency, here EPA, as best suited to serve as primary regulator of greenhouse gas emissions. The expert agency is surely better equipped to do the job than individual district judges issuing ad hoc case-by-case injunctions. Federal judges lack the scientific, economic, and technological resources an agency can utilize in coping with issues of this order. This is the Supreme Court saying, this stuff's really complicated. And Congress has created federal agencies with lots of experts and scientists and engineers and economists who can figure this stuff out. Wouldn't you rather have them figure it out than hope that we and all of the other judges out there that are going to get all these lawsuits have to figure it out? And while this is just dicta in the opinion, it is something that I think is fair to say has influenced what other courts have done since. Now, this case meant that you could not sue in federal court under federal common law. What it left in place is the fact that you could sue alleging a nuisance under state common law. The one catch is that any such claim has to be filed under the substantive law of the source state. So if I'm in Vermont and I want to sue a coal plant in Ohio, and the claim I have to make is that the emissions are a nuisance under Ohio law. And that's obviously harder, right? Because if a facility is operating in Ohio, you might doubt that it's creating a nuisance, and we might think that, for example, Vermont might have more stringent standards than Ohio does, fewer coal plants. And so what's left is there, it's viable, but it's harder to meet because you have to base the nuisance claim on the standard of the source state. Well, a lot of jurisdictions are trying to meet these claims, and I'm going to highlight a few that are going on now. Here are a bunch, and I'll tell you what the color coding is, that are in court right now. Most of these cases have been filed in state courts because they're making state law claims, right? So a bunch of cities and counties in California sue large corporations that have facilities in California and elsewhere, and in state court because they think state courts will be more favorable, especially given some of that dicta In the AEP case, what do the defendants do? In most of these cases, the defendants are oil companies. The oil companies seek removal, get the cases to federal court. And some federal courts have accepted removal, some have not. Some of those that have accepted removal have then dismissed the cases. So for example, the San Francisco and Oakland case, that was removed to federal district court in California, and then Judge Alsop granted the motion to dismiss, saying this is a political question. Right? These issues are just too big for me as a little district court judge. Congress figure this out. But I don't know what sort of remedial order I, as an individual judge, could enter to deal with these sorts of claims. The New York City case, which was filed in federal court, was dismissed. That case has been appealed. Oral argument is on November 22nd. Right? So, I mean, this is stuff that's moving. I had to check this morning and be like, okay, what happened in any of these cases? Do I have to update what I'm going to say? Because stuff is moving that quickly. The San Mateo and Marin County cases, the Boulder case, the King County, Washington case, the Boulder case and the San Mateo case, those were both remanded back to state court, but the oil companies are appealing the remand decision. The Rhode Island and Baltimore cases are both really interesting. In both of those cases, the federal courts remanded those cases back to the state courts and said proceedings can continue while any appeal of the remand order proceeds. So just a few weeks ago, some of you may have seen the story in the New York Times, the defendants in both the Baltimore and Rhode Island cases went to the Supreme Court and said, please stop these trials. Put another way, don't make us go through discovery until we've exhausted our appeals on the remand question, because we think if we can get these cases removed to federal court, we think we can get the cases dismissed. And the Supreme Court denied those motions just, it was, I guess, October, I think, 21st or 22nd. And so those trials are scheduled to start soon, this calendar year, unless something really unlikely happens with, yes?
If the federal court takes jurisdiction and doesn't remand, it's supposed to be applying the source state substantive law or not?
Yes. Right, so the reason for the displacement doctrine in AEP, it actually goes all the way back to Erie Railroad. You guys remember that case from first year civil procedure class, right? What is one of the bases for Erie as a doctrine? The idea that federal common law is disfavored, right? And so our choice of law regime is based on the idea is that we'd rather not, insofar as we're relying on common law, we want it to be state law. And so the standard for displacement, as opposed to preemption, is very loose because the Supreme Court maintains the idea that state common law is fine, but federal common law is icky. Federal law should be things like statutes and regulations. And so anything Congress does that gives us an excuse to say federal common law is gone, we will jump at it. Whereas if the claim is preempting state law, a lot more things go into that. And so, yeah, so no matter where these cases are, but the source state law has to be applied. But as a practical matter, I mean, given the things the Supreme Court said in the American Electric Power case, given the fact that there are particular justiciability doctrines like the political question doctrine that federal courts will hear, the strategy is for the oil companies is get these cases removed to federal court, get the cases declared non-justiciable, and then the cases can't be rebrought in state court. And it's both just in terms of what claims can be made in federal court, but I think also just a realist assessment that these sorts of arguments will get a more sympathetic hearing from a federal judge than a state judge. And I think what we've seen in the behavior of both plaintiffs and defendants suggests that that's a widespread assumption, and I assume it's correct. So these cases are going on. Now, these cases are ambitious. Right, these are claims, Rhode Island is making a claim like Massachusetts, we're going to lose our coastline. Some of the cities are making claims about how the costs of providing various sorts of city services will increase as a consequence of climate change over time. What's worth noting is that the point of these cases is certainly they want discovery. They'd like a trial. But like a lot of cases where we see broad gauge nuisance type regulation, maybe think of the opioid litigation that we've had here locally, the plaintiffs are just as happy if they can get some sort of global settlement. So when understanding the strategy of these cases, it might not be litigating these cases to final conclusion. It may be simply and if you talk to some of the attorneys, it clearly is, putting enough pressure on the defendants, both economically and from a PR standpoint, that they settle on terms that allow for progress to be made in reducing greenhouse gas emissions. And the volume of these cases, the fact that they have been harder to dismiss or get rid of than some of the oil companies had thought or hoped, means that strategy certainly could be effective. Okay, lastly, because I only have a few minutes left and I can't talk about the subject without talking about this one case. There's a case that some of you may be familiar with. It's called, been referred to as the trial of the century, Juliana versus United States, a case organized by an organization called Our Children's Trust, case filed in federal court arguing against the federal government for its failure to address climate change and for actions that it has done that have made climate change worse. I should note this suit has been replicated in a wide range of jurisdictions. There are a number of state-level suits bringing similar claims. On this one, because it's against the federal government, has attracted the most attention and is one to pay attention to, because at this precise moment, it certainly looks like it could be the next climate change case to get to the Supreme Court, certainly on the non-administrative law side. So what are the claims? And these claims are ambitious, and that is an understatement. One claim is that there is a substantive due process right to a stable climate system, and that the federal government has violated this right by, among other things, permitting and facilitating and encouraging fossil fuel development. And that secondly, the federal government has a public trust obligation, that it holds things like the atmosphere and water systems and navigable waters in trust for us and future generations. And insofar as it is allowing, permitting, or encouraging activities that undermine the sustainability of those resources, it is violating that public trust. Key to the legal theory is that the plaintiffs are children, so the plaintiffs are all folks that are not eligible to vote. And part of the basis for that is saying that any claim that this should be resolved by the political process doesn't help the plaintiffs, because the plaintiffs can't avail themselves of the political process in the same way. Ambitious claim. The district court last year refused to dismiss the case. The district court, and this is important, and for those of you that litigate, you'll understand why this is important. The district court also refused to allow an interlocutory appeal of the refusal to dismiss the case, which may have been a mistake as a strategic matter. But in terms of justifying or explaining the decision, and there's a lot to get to, and I've gone on more than I wanted to. The district court said that plaintiffs have alleged that defendants played a significant role in creating the current climate crisis, that defendants acted with full knowledge of the consequences of their actions, and that defendants have failed to correct or mitigate the harms they helped create in deliberate indifference to the injuries caused by climate change. The federal government has known for decades that climate change is a problem, yet it still allows oil and gas development on federal lands. It still allows offshore oil drilling. It still operates all sorts of programs that are designed to facilitate or encourage the production and burning and combustion of fossil fuels. The federal government is contributing to these harms. The district court also said federal courts too often have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it. Even when a case implicates hotly contested political issues, the judiciary must not shrink from its role as a co-equal branch of government. So the district court denies the motion to dismiss last year, schedules discovery in anticipation of trial, discovery against the federal government. You might imagine the Justice Department was not too thrilled. Justice Department goes to the Supreme Court and says, put a stop to this. The Supreme Court issues an order which doesn't say we're going to put a stop to it, but does kind of say, are you guys serious about not granting an interlocutory appeal? These are major questions. Whether you think the district court got them right or wrong, the standard for interlocutory appeal, the fact that this is a major question about which there could be substantial disagreement, that is dispositive of the case, clearly satisfies the threshold that we use to allow cases to get an appeal before final judgment. The Ninth Circuit says, oh yeah, and the district court says, okay, I guess so. And the district court writes an order saying, we think what we did was right, but fine, have an interlocutory appeal. That appeal is pending now. Really quickly, because I know the hour is just about up. I'm going to offer a prediction. I don't offer a lot of predictions about this kind of stuff, but I'm going to offer a prediction. This case will lose. The thing that matters is how it loses. And in particular, where it loses. If it loses in the Ninth Circuit where it's pending now, it's an interesting case. It generated a lot of publicity that certainly increased the awareness and salience of the issues of climate change and certainly served a purpose in that regard. If the case fails in the Ninth Circuit, the Supreme Court, I'm pretty sure, does not take it up. If it doesn't fail in the Ninth Circuit, it will go to the Supreme Court. And if it goes to the Supreme Court, the Department of Justice is not going to say, oh, just kind of tweak what the district court did a little bit. The Justice Department is going to ask the Supreme Court to issue a ruling that will make not only this case, but a wide range of other cases go away. Perhaps ask the Supreme Court to revisit the standing holding in Massachusetts versus EPA. Perhaps issue a ruling that has dicta that not only gets rid of public trust cases, but that gets rid of nuisance cases in federal and state courts. And in the current court, you might get that. In the sense that this is a court, the current court is not likely to be particularly sympathetic to this case. So like I said, this case, the question is not what, I am fairly confident in terms of the ultimate outcome. There are questions of timing to be sure, but the real thing to watch is, does the Ninth Circuit make this case go away in a way that does not require the Supreme Court to intervene, so that other cases that are operating on other similar related theories or other cases that involve similar theories to this can continue to percolate and operate in the lower courts, which they will be able to. And the Ninth Circuit could certainly write an opinion, for example, that doesn't affect Oakland and San Mateo and San Marin counties' nuisance cases. The U.S. Supreme Court might be less inclined to do that. U.S. Supreme Court. Last thing I'll say, what this all the underlying or kind of takeaway of all this is that these cases are really hard. We have a lot of them in federal court and in state court, and courts are struggling with them. Climate change presents a lot of questions that courts have not had to confront before, and they're figuring it out, and they might figure it out. But it's also possible to look at all this and say, there are other ways we could try and address this problem. And if the courts are having a hard time figuring out how various doctrines apply to climate change, maybe we should look elsewhere for solutions on climate change. But of course, I could understand why folks might not be optimistic about that alternative. So on that gloomy note, and I hope that's a sufficiently gloomy picture, I will end. Thank you for attention, and certainly try and enjoy your weekend. Thank you. I'm happy to hang out and take questions. I know that you only signed up for an hour of CLE, so I am not offended if any of you go off to that. And I know that there's a law alumni association board meeting, but I'm happy to hang out and take questions or talk to folks down here for a little bit. Again, thank you very much, and see you all soon. There's a question about which is the strongest case. I mean, from a timing standpoint, Rhode Island and Baltimore are strong because they're going to get to a point sooner where you get discovery and you get other procedural things happening that the defendants don't want. In terms of the theories that are being used, there are things about the Boulder cases that I happen to like, but I think timing matters a lot in those cases, because part of the point of those cases is pressure for settlement.